And Don? Great. No. Can you see from over there?
Hello?
Hey, John, this is Brenden. Can you hear us? Yeah. Are you using a headset?
No.
How was that? Okay, Don, can you hear us?
Yeah.
Okay, great. We have a very good connection, so we can hear you extremely well. Okay, well, thank you. Welcome. This is the panel 1 on civil liberties, security, and law enforcement. And I want to thank Ron for that kind of sweeping look at the relationship between the internet and human rights and security. And in this panel, we're going to kind of, as he was saying, pull back the covers and look at some specific issues occurring in ICANN related to domain names. From the registration to the resolution of domain names, the policies that govern those activities matter to the way we communicate over the internet. These activities occur at the intersection of civil liberties and security. Where are these policies that are governing these activities being developed? And where are they being enforced and challenged? Are these policies addressing legitimate security concerns while protecting free expression and privacy? How can we achieve both of those outcomes? This panel will examine those questions by looking at 2 issues that have dominated domain name policy over the past year. The first being the seizure of domain names, and the second being the Registrar Accreditation Agreement negotiations occurring at ICANN. These issues raise fundamental questions about the role of contractual regimes, extraterritorial jurisdiction, and participation in global internet governance. To help us look at these questions, we have a distinguished panel here. On the phone, we have Don Blumenthal, who's a senior policy advisor at PIR, the Public Interest Registry, that's .org. He's a lawyer. Many of you know him, but for those who don't, he's a lawyer and also an academic at an I-school, like me, an information school, rather. A cybersecurity and privacy expert. He serves on the SSAC, and where he's contributed to several of their documents. He has a law enforcement background, created and directed the FTC's Internet Lab, which systematically collects and indexes illegal activity online for prosecution. Seated to my left is Elliot, the president and CEO of Tucows. Tucows is a well-known Canadian-based registrar, the largest wholesale provider of domain names. He's a well-known champion of vital interests to service providers and internet users, including privacy, ICANN reform, and registrar matters, and also emerging technologies. I think the last time I ran into you was at an identity conference that had nothing to do with ICANN. So he's a man of many talents. Seated next to Elliot is Wendy Seltzer, the founder of the Chilling Effects Clearinghouse, which is a collaborative archive founded along with several law schools and the EFF to protect lawful online activity from legal threats. It allows recipients to post cease and desist, and as far as I know, other types of materials, notices rather, allows them to submit them and to the site. So there's some transparency created around these processes, and receive information about their legal rights and responsibilities. In addition to her research on IP, privacy, and free expression online, she's a longtime ICANN participant and representative of non-commercial interests, serving in numerous roles from the GNSO, counselor, to the ICANN board. Next to Wendy is Genevieve Rosloff, who is an attorney at Durie Tangri. She is a former trial attorney at the DOJ's Antitrust Division, Telecommunications and Media section, with a wide range of experiences from electronic privacy and copyright to competition and consumer protection. Most recently, she's been involved in the defense team for Roja Directa, a domain that was held by a Spanish company and was seized by the U.S. Department of Justice in 2011, and the complaint was recently dismissed. Very interesting story, and we hope to hear a lot about it. And finally, we have Kleiman, who, as you heard earlier, was a co-founder of NCUC and helped found ICANN. She's active in numerous activities dealing with free speech, IPRs, fair use protections, privacy, data protection laws, and due process, and has been involved in numerous projects, too many to list, but just a few of them, the new GTLD DAG, co-authoring the UDRP and URS, and also the WHOIS review team. And in addition, she's worked with the U.S. government on domain name takedown issues. So these are our panelists, and the structure of the conversation that we're going to have, we're just a general structure. We don't have to stick precisely to it. But we'd like to spend some time looking at domain name seizures first, and then we'll look at RAA negotiations. And what I'd like to do is have the perspective of a couple of participants, followed by, maybe 8 or 10 minutes of that, and then followed by Kathy Kleiman, who's graciously volunteered to be the respondent to those two positions and kind of give us a summary and maybe a little bit of an indication of where the debate may be going. Followed by those kind of debriefs, I'd like to talk about how we go forward from here. How do we protect non-commercial registrants' privacy and civil liberties while ensuring security? And where can we make improvements to benefit all interests? And then finally, I'd like to engage the audience and do a lot of Q&A, because I'm sure you have a lot of interesting questions for our experts here. So first thing, I'd like to turn it over to Genevieve Rosloff to give us a little bit of background about the Roja Directa case.
Sure. As Brenden mentioned, I represented Roja Directa, a client of my firm's whose domain name was seized in a sweep of domain name seizures by the federal government in the United States. My client, Roja, is primarily a linking site. It provides discussion forums. It provides discussion forums for political stuff, sports, and it also provides links to where you can find content hosted elsewhere on the internet. Now, Roja Directa does not itself host any of the content that the government has alleged to have been infringing copyrights. Roja Directa is based in Spain. Its servers are based right here in Canada. It's not a U.S. company, and it does not have any property in the United States. On the eve of Super Bowl 45, which is in the U.S. a national holiday of sorts, the federal government, under I believe it was Homeland Security in the Immigrations and Customs Enforcement Unit, went through a sort of secret process and got a warrant for seizure of rojadirecta.org and .com domain names. The warrant was based on Immigrations and Customs Enforcement agents' probable cause belief that Roja Directa was essentially what I just described to you, linking to content found elsewhere. The agent said that Roja Directa itself was not hosting the content, but that the links were to streams of sportscasts found elsewhere. Based on this, a magistrate judge in New York issued a warrant, and the next day the domain names were handed over to the federal government. Now, Roja Directa did not find out about any of this until one morning when it woke up and went to its website and found out that rather than seeing the content that it had built, it pointed to a site that I wish I had a handout here of that, but said, big banner, this domain name has been seized by U.S. Immigrations and Customs Enforcement pursuant to a seizure warrant issued by a U.S. court under the authority of 18 U.S.C. 981 and 2323, and then described the crime of copyright infringement. I just looked this morning on some of the sites that had been seized, and the banners now, it looks like, will take you to a YouTube video that the government has created about piracy. So at this point, we, the client doesn't know what to do, and so we go about trying to figure out what the next steps are. In the months that followed, this was sort of a Kafkaesque experience where we first tried to figure out who was in charge of this and who were the appropriate officials to contact. We tried contacting the Department of Justice, Immigrations and Customs Enforcement, Homeland Security. We left a bunch of messages and really weren't getting any responses and getting told to call this person, no, call that person, and just pretty much bounced around. Finally, when we left somebody a message telling them that we planned to file a lawsuit, at that point we got a response. And then began sort of engaging in negotiations with the government to try to see if there was a way to get the site back without resorting to litigation or official forfeiture proceedings. That was unsuccessful, so we took the issue to the court and argued that we should be entitled to get the property back pending the outcome of whatever proceedings were going to unfold at this point. At this point, the government hadn't actually brought a forfeiture proceeding against the site. It had just seized it. The only authority for that was this warrant that had been obtained. And we brought a suit affirmatively against the government, saying that we should get the property back until the government figures out, what it's actually doing. That motion, unfortunately, was denied. Part of the problem here was that the statute, the law under which this forfeiture was brought, was not really geared toward domain names. It was originally geared toward property such as a getaway car or money that was used in money laundering. And there, you could maybe get your car back pending the outcome of the proceedings if your car was necessary for you to get to work. In our case, we argued that our Roja Directa was suffering from business harm in the form of declined traffic. At this point, it had set up mirror sites on non-US based registries like .es and some others, but nonetheless was still not seeing the same amount of traffic that it originally had. We also were arguing that this was a fairly egregious First Amendment violation in that this seizure had been done based on a very low burden, and there was no determination that the content on the site was actually infringing. Moreover, most of the content on the site was not even alleged to be infringing. It was discussion forums and discourse and everything else like that. That did not resonate with the court, unfortunately. So in the months that followed, the government tried to sort of settle on a theory of its case, in the meantime holding the property. The government really couldn't settle on a theory. It didn't seem to understand criminal copyright infringement, especially with respect to the internet and linking. It first was, claiming that it was the Roja Directa site and operators themselves that were directly committing criminal copyright infringement by providing links. Then it said, no, wait, I guess maybe it's these third parties that are uploading stuff, and Roja Directa is somehow secondarily liable for linking to that, and there's a crime for secondary liability under some made-up thing. So the government never really did settle on anything. And a few weeks ago, in late August, the government, out of the blue, basically pulled the plug on the case and gave the order. The court issued an order directing that the registries give the domain names back to Roja Directa. And today, instead of seeing a lovely banner from Homeland Security, you will see the Roja Directa site.
You know, I think what's really striking about this is I want to tell a story from last night. Last night there was a football game on. It was Pittsburgh versus Tennessee, and it was on the NFL Network, which means in Canada, through arcane rights proposals, it's not readily available. So I went to go watch, as I will do in those circumstances, a free stream online. Now, I searched for it, and this is something that you know, most people half my age and younger do all the time. You know, and I'll ask my kids for help when I'm struggling with this. The results on the first page included doing exactly what Roja Directa did. Sites like Yahoo, Hewlett-Packard, SB Nation, which is the second largest or third largest sports site, and my favorite, and always the #1 link when I look, Christian Post. Now, what all of them are doing is exactly the same thing. They're not policing their comments or forum threads. In HP, it's the help sections that are doing exactly, really, it's the HP Support Center where you can find the link to the NFL stream. So, you know, it's really, you know, highlighting both the absurdity of it and the inconsistency in the application. So.
No, that's absolutely right. That's certainly an argument that we were trying to make, analogizing this to a search engine, whereas the government was claiming that we were doing something different than what a search engine does because we were specifically organizing information in a way that makes it responsive to what a user is looking for. Well, that seems to be what a search engine does. So,
Great. Well, thank you for that interesting background. Don, I just want to make sure, since you're a remote panelist, did you have any particular comment on Roja Directa? Or
First, did the adjustments I made help at all in the audio?
Yeah, they're great. We can hear you loud and clear. Thanks.
All right. Not specifically in Roja. Just Roja Directa was an example of what to do wrong right down the line. Whether it had to do with the government not quite being sure what it was looking at for the issues of extraterritorial how to do everything wrong. I think there are problems with focusing even on ICE's operation in our sites because the whole area of intellectual property, digital content, things like that is such a hot button issue. The fact is there are other areas where takedowns are done where I think it's clearer that there's a reason for it. I think it's clearer that the government isn't necessarily overreaching. Now, I have a problem with takedowns in general because they're so easy to evade. But the merits of the case, I think, are really better discussed in the context of things that are less controversial. I just want to take very quickly a second to mention that, and it would be nice if we could have done it earlier, but we didn't. SAC posted a paper on domain blocking, SAC 056, about an hour ago. So folks might want to start looking at it, but obviously we can't talk about it much since I'm probably the only one in the audience who's seen it.
Don, it's Kathy. You got a no on that.
Pardon?
It's Kathy. Someone in the audience says no, that they've seen it too.
Okay, I don't know who else is there. That's one of the advantages of me still sitting in Ann Arbor.
Yeah, I wanted to, Don, it's Elliot. I think that when you say, that we should avoid looking at those facts, that's one of the two main points that I'd really like to tease out in this panel. I think those are exactly the facts. Things like Roja and things like ICE are exactly what we should be looking at. Because our problem in discussing intellectual property issues deeply inside of ICANN, but also more broadly as they apply to the Internet in general, is that the dialogue is dominated by creating these tools to deal with real problems. But what we never have is balance in the discussion and enough dialogue on how every single one of these tools is misused. We see this overwhelmingly with the UDRP. We're seeing this repeated now with the URS. We're seeing, Wendy's got a website with Chilling Effects that's dedicated to this misuse. But when we have the dialogue inside of the new GTLD process or UDRP reform or any of this, all we talk about is the harms to property holders. We never talk about the spillover and much greater harms to innocent victims. And it's so striking to me that a simple, fundamental principle of administrative justice, which is, that we should have 10 guilty people go free in criminal law, to protect one innocent man from being found guilty, is totally thrown out the window in all of these intellectual property discussions. And in fact, we'll have 10 innocent people found guilty so that one actual harmed party can be protected. And so, I couldn't disagree more with what you said there and would really flip it on its head. Thanks.
If I may, I guess that depends on what we're talking about. If we're talking about intellectual property issues, I absolutely agree with you. If we are talking about the whole subject of domain takedowns as a law enforcement measure, intellectual property is a big part of it, but it's not the only part of it. And I think too often some of the other reasons for the use of takedowns gets lost in the emotion that surrounds IP.
Again, I couldn't disagree more, and I say that with respect, but when we'll be talking I promise you, over the next couple of days in the LEA panels that we're going to have, what we'll hear is intellectual property protections defended on the basis of child pornography or pedophilia. And I've called this out before, and I've asked for evidence a number of times, and we never, ever get that. So what it tends to be is either, I don't personally, it's a personal view, I don't think that an online stream of the Super Bowl is a criminal act, although it may be wrong. It's a civil or a property act, not a criminal act. And the problem is that when we mix the two, the legitimate criminal activities end up getting dragged back into these intellectual property discussions. So I think both sides lose. We overprotect on the intellectual property side, and because of that, we make it more difficult to put in real protections for real criminal acts.
Great. I think, Wendy, did you want to add something?
Yes, and I think it's important that we step back and characterize these domain takedowns for what they are as takedowns of speech often. The domain name is a tool of online expression. Certainly, some people at some times use it for unlawful activity, but the bulk of activity online is people expressing themselves, people engaged in communication with one another, people sharing, sending, or receiving information. And so by that light, it's important that we use the standards that we use to assess free expression. In the United States, that's the First Amendment. Around the world, that's the rights to send and receive information in the Declaration of Human Rights and in principles of national and international law. And there, too, in the U.S., we have a long history of very close scrutiny of law that impacts free speech. We look for laws that cannot be overbroad or under-inclusive. And when domain names are taken down, they are typically both overbroad and under-inclusive. Rather than being narrowly targeted at the unlawful conduct, they sweep broadly, taking down lawful speech and lawful interchange of information, and they don't go far enough because for the sophisticated criminal or the sophisticated evader of rights protections, it's still easy to find the content that remains online when the domain name pointer in the registry has been removed or disabled. And so from First Amendment jurisprudence, we look at overbreadth and under-inclusiveness as a sort of key to, is the law properly targeted? And if it's not properly targeted, we look for better targeted measures. So similarly in the domain name context, I would say that should lead us to look for better measures targeted at the unlawful activity. I, too, am not arguing that we should permit unlawful activity to continue, but that we should look for better targeted modes of prosecuting that while permitting free exchange of information to continue.
Don, this is Brenden. So can you kind of characterize the kinds of takedowns that PIR sees? I realize you have a PIR takedown order page, but I'm also interested in takedowns for malware, botnets, that type of thing. And are there any impacts there potentially for protecting lawful speech?
Yeah, absolutely. To the last part there. I mean, we see the range of possible takedown orders. Now, the vast majority are intellectual property, whether we're talking law enforcement or private or intellectual property. I'm sorry, whether we're talking law enforcement or private suits. And the subject matter ranges from intellectual property, which is the vast majority, to takedowns that are related to malware, botnets, clearly criminal activity. And even those can be both private actions and law enforcement actions. But I assume a lot of people in the audience are aware of 3322.org, which was a botnet case, but that was an action brought by Microsoft, not law enforcement.
Great, thank you. So I think this might be a good time to bring in our respondent.
And this is Kathy Kleiman, a respondent not in defending what we've heard, but trying to get the big picture, perhaps, because it's interesting that what I'm seeing, and in this way I'll respectfully disagree with Don as well, there's a pattern here, and it's a pattern I find deeply, deeply disturbing. The pattern involves domain name takedowns, and then we'll see it in other areas that we talk about as well. But with domain name takedowns, let's look at where we're going on this. We have ICE, the Immigration and Customs Enforcement, taking down domain names in the middle of the night. There's no opportunity to respond. There's no notice of the case. You find out when your domain name goes down. And by the way, guys, when you take a domain name down, you're pulling out speech by the roots. There may be a web page that has some counterfeit material on it, or something that's a concern. But there could be many, many other web pages. Somebody got one site got taken down, one domain name was taken down, and there were tens of thousands of other websites on it, in addition to the one that was of concern. So this is not narrowly tailored, as Wendy would tell you. You're also pulling down the listservs in the email, and none of this is recoverable, guys. This all gets lost. There's no way to recover it when the domain name gets taken down. So with ICE, we're seeing no opportunity, no notice, no opportunity to respond before the action takes place. Let's look at some of the national legislation that we're looking at. SOPA, Stop Online Piracy Act, as well as its predecessor, COICA, the Combating Online Infringements Copyrights Act, similarly had no opportunity to respond and no notice. I couldn't believe it when I was looking at this legislation. I'm like, wait a second. Since when do we only listen to one side of a dispute prior to taking action, particularly when it involves speech? And by the way, it's worse. A lot of the takedowns are going privately. This is what Brenden raised with Don, and it's worth talking about. Although .org, by the way, is one of the really good guys in this. But registries and registrars are taking private action through their terms of service, through their contracts. They're evaluating they're evaluating concerns individually, not providing notice, not providing opportunity to respond to domain name registrants, and domain names are coming down, not one or two, by the tens of thousands. And we're moving in that direction. So whether we're looking at legislation, whether we're looking at law enforcement working through the courts or not through the courts, whether we're looking at private rights of action, we're seeing a complete lack of due process. And this I find deeply, deeply disturbing, especially given what's involved with the domain name and how much speech is involved. And international speech. I think it was raised, one country looking at the speech of other countries or looking at the activities of the other countries. International issues, jurisdiction, again, that opportunity, lacking that opportunity to respond is deeply disturbing, and it's part of our pattern.
Brenden, if I can just
please do.
Clarify a couple of things there. One of the problems with domain seizures, takedowns, filtering, whatever you want to call them, is that in fact they don't take content down for the most part unless servers are seized, which is rare. And just to address something Wendy said, it doesn't take a sophisticated user to evade a takedown order. Anybody who played with Mafia Fire saw how that could be done. For the most part, the content is still out there, and it can be found. And I'm only mentioning that because it is such a point in favor of saying that the whole process makes no sense. I used to be in law enforcement. I do work for a registry, but well, as Kathy knows, I can be quite cynical on a lot of these traditional arguments.
So Don, just a follow-up question. So, I haven't read the SAC report on domain name blocking, but I'm assuming that report does go into kind of this ineffectiveness of using takedowns as a tool of enforcement.
Yes, it does. It's something of an extension of the domain blocking report we did about a year or so ago.
Okay, I'm just going to quickly ask if there are any questions from the audience, because I want to change the order just a little bit, but I'm only going to take about 5 minutes here for questions on this topic, then we're going to move on, okay? So, Bertrand, and there was one back behind you. Go ahead.
Right there.
Right here.
Right where it's normally there for public
forum. Right in front,
We're
yeah.
used to finding it. Come on. Right there.
Hi, this is Bertrand Lachapelle. First of all, congrats on the RSAC report, which I encourage everybody to read and distribute. Second thing, following what Jenny said, what we're witnessing with the Roja Directa, but also the Postdoc case, is a trend towards using the DNS as a content control panel, and this is not what it is made for. In the debate, what strikes me is the fact that there is no distinction made in terms of seizure between seizures that can be justified by the harm to the system, the infrastructure, the DNS, and seizures that are tools towards content. And I don't know if the expression neutrality of the DNS is going to evolve in this debate, but there is such a thing. The DNS is not a content control panel. It is not. And any seizure, I believe, that I'm speaking personally, and of course not on behalf of the board in that regard, but any seizure should be justified by something that has to do with the infrastructure and not the content, for all the reasons that are stated in the report. The second thing is we're witnessing a huge extraterritorial extension of sovereignty. And without getting into details, I'd be happy to discuss that further. An argument that I'm using towards a lot of governments is to say, beware that the excess of sovereignty kills sovereignty. Because what a lot of governments who are jumping on their chairs to say, we need to reaffirm our sovereignty on what is on our territory, basically, do not understand that they are giving tools for a very unbalanced structure of sovereignty. Because of the location of the operators, it can be the intermediaries, it can be the DNS operators, and so on. The reality is that some countries have more operators on their ground. And if they do apply their law without limit, they do exercise their own sovereignty on the territory of others. And governments should be worried about that. Not only civil society actors. They should be worried about somebody else exercising sovereignty on their own citizens. And finally, one topic where I may not be completely in agreement with some of the things that have been said. Yes, the DNS is an element of freedom of expression. But I would like to make an analogy. It is not so much what is in the line of the domain name that is the expression. What I understand as an analogy or metaphor is that domain names are like doors to spaces. Imagine that we have, this is a website. This room is a website. We're having a discussion there. You can enter this room by many, many doors on the internet. It can be accessible by as many domain names, addresses you want. When an authority is seizing an address, it's actually the equivalent of putting a police squad at one of the doors. But in many cases, you have many, many other doors, and you can build as many doors as you want when one is being blocked. So the key question is more freedom of reunion than freedom of expression. The question is, how are spaces online, private, public, semi-private, semi-public, and what is the right that you have in freedom of expression cases to be in a room and have a discussion? Infringement of copyright is another issue. But for freedom of expression issues, it's mostly a question of the right to be in the room and access the room, rather than the domain name itself being a matter of freedom of expression. But I know that not everybody in NCUC agrees with me.
Thank you, Bertrand. Any responses to that?
You know, I certainly would push back on that metaphor in a couple key places. First, you know, I think that we can talk about de facto or de jure here. You know, there's you know, technically a domain name is sitting in front of the content of a website, and technically there are alternatives, whether they are IP addresses or alternative namespaces. But practically speaking, the core domain name is the, you know, there's two important elements. Practically speaking, the core domain name is the primary way that the bulk of users will find the content. So, you know, the fact that there is that there is a window on the third floor somewhere that you could also go in, you know, doesn't change the fact that putting a padlock on the front door, you know, has a material impact that has to be weighted. And I think the second important, you know, point against that metaphor is that there is a separation of ownership and distribution in the supply chain. It is overwhelmingly the case that in the DNS, the supplier of the domain name, the registrar, is not also supplying the servers and the web tools that the content is being created and hosted with. And the importance there is, you know, the domain registration business is a very, very thin layer of a much bigger piece, and it also has very, very thin margins. And so what you see again in practice is domain registrars who are very, very simple in their application with complaints. The easiest thing to do is say in your terms of service, any complaint, we're just taking it down. And what happens is the intellectual property community, they're brilliant at finding the low watermark in the system, and they'll just use that. So, you know, in other words, you'll put the complaint at the place where there's the least resistance to it. And so, you know, it's okay to separate those things, but in practice, it's a huge material impact on free speech.
Just following up on that, I really agree that it is sort of the easiest target, the domain name, and I think that in the case of these U.S. seizures, it's partly because a lot of the companies that are allegedly engaging in the infringement are located abroad, and their servers are not located in the U.S., so the only thing that they can go after is what's in the U.S., which is the domain name. Additionally, the law permits the seizure of anything that was used to facilitate criminal copyright infringement, and the problem with that is that it's extremely overbroad. I mean, virtually everything, you know, if you know, in this room, criminal copyright infringement were occurring, you know, think of how many things might be facilitating it. They could seize this whole building. You know, there you run into the problem that it just, that law, the law under which these seizures are being effected are really not tailored and not well suited for this purpose.
Thank you. Go ahead.
It seems to me that these sites like Roja, Directa have a lot of...
Could you just identify yourself?
I apologize. Richard Pietro with citizenbridge.org. I'm relatively new to the space, but these sites like Roja, Directa, they have a lot of advertising on the site. So I guess my question is, if they didn't have advertising on the site, would they still be as criminally liable? Because they're not necessarily profiteering on the streamings and the online content.
I mean, that would be certainly debatable, and I believe that there are the current definition under U.S. law of criminal copyright infringement. There doesn't, if other conditions are met, there doesn't have to be a commercial gain, and even a commercial motive is sufficient. And I think that the way courts have construed that is, you know, virtually anybody who is operating something to try to obtain any benefit is really, you know, sort of doing it for a commercial or financial motive. So I think that would be a really difficult, you know, I'm trying to imagine if it was some sort of site that was, you know, linking to or giving away content totally for free with no motive other than just to disseminate free information, you know, maybe there would be an argument there. So that's certainly a possibility.
But, you know, I want to remind you of the story I told. The HP support site is not ad supported. What it is policed perhaps in a 24 or 48-hour lag, which means if you're putting up a stream to a timely event, all you care about is your organic search result and the fact that it's going to live for 24 or 36 hours so that you can take advantage of your affiliate program. It has nothing to do with HP. So the issue really around stuff like this is in the, you know, how often are your comments policed more than anything else, much more than that.
Great. This has been a fantastic discussion. So I think, oh, is there one more question? Yeah, come on up. Oh, you're out of mic.
Hi, my name is Evan Leibovich. I'm with the At-Large Advisory Committee, and by the way, welcome to Toronto. My question for the panel, I guess, is about the example of WikiLeaks, which as of a few seconds ago, I was able to go onto Google and search for a website that has been declared an enemy of the state. This goes beyond conventional IP. This goes to the fundamentals. And if this site can't be taken down, what does that say about the mechanisms in use? And are there any lessons to be learned from the experience of WikiLeaks in both the protection of speech and the ability to deal with government attempts to take it down? Thanks.
Thanks, Evan. I think the WikiLeaks case illustrates the principle that Elliot mentioned earlier of governments seeking lots of different pressure points. At various times, plaintiffs have tried to go after the WikiLeaks domain name. They put pressure on the payment processors who are accepting donations for WikiLeaks. So it's MasterCard and Visa, we're told, to stop processing payments. At times they've gone after the cloud storage providers where pieces of content were hosted to provide access for WikiLeaks. U.S. government officials have made remarks that these things should not be tolerated, and that has caused Amazon and Visa and MasterCard to pull their support for financing or hosting, all of which were useful to facilitate speech. By contrast, the fact that WikiLeaks has remained up, I think, speaks to the power of the distributed community in responding to keep material online. We often speak of the distributed nature of the Internet and the network of networks and sites that live on that. So while WikiLeaks remains sort of a community of individuals with shared interests who can find new homes for material, and when one root or host site is taken down, then the material itself can remain up. So the sort of distributed organization is a good counterpoint to the sort of centralized attack on a few notable choke points.
Great, thank you. I'm going to ask you to hold your question to the end, just so we have enough time to get through everything, but we will come back to you, I promise. Okay, so great discussion. Our next topic, the Registrar Accreditation Agreement. Most people are probably familiar with this ongoing saga here at ICANN, but for those of you who aren't, the RAA is a fundamental component of ICANN's contractual regime, and these contracts have wide impact on ICANN, the registrars and registrants. Now, it would be impossible to recount the entire history of the RAA negotiation, but since the board resolution at Dakar in 2009, essentially there's been two processes at work occurring in parallel. 2011, excuse me. Two parallel processes shaping the RAA. One involves the GNSO and the role of a consensus policy making. The other involves bilateral negotiation between ICANN and the registrars. What has made the latter controversial, a couple issues around it, are whether bilateral negotiations are the appropriate process, given the widespread impact of the decisions taken on the parties that are external to that negotiation, and also the seemingly preferential input of LEAs and the GAC to those negotiations. So I'd first like to turn it over to
Brenden, what's a LEA?
Law enforcement agency. Sorry. Sorry. I'll turn it over to Elliot, and then we'll have Wendy. Okay.
Yeah, I think that there's a couple pieces I want to tease out. The first is around bilateral negotiation. I think that it is absolutely appropriate for a core commercial contract to be negotiated between the parties. I think what's unique in ICANN, I'll highlight that, your PayPal agreement, if you have a PayPal account, has as much impact on you, perhaps more because it's dealing with more commerce than does the RAA on your domain registration. So, the fact that there are other impacted parties doesn't change that nature, that it is a commercial contract. What's unique in ICANN and appropriate is that there is, I think coming through this process, a nicely evolved approach to letting other parties have their input. And I think that, the registrars in particular have come out and said, we think it's great, we think there should be robust discussion, we think that everybody should have their input into what issues there are. And then the staff should distill that and bring that forward into the negotiation. There should be constant, there is posting of every draft agreement, and then there's further input taken. There has been a big problem with this process, singularly, And that's that some interests have been overrepresented and others have been not even underrepresented, but invisible. And primarily the interests that are overrepresented are, of course, LEA, that's Law Enforcement Agency, Kathy, and intellectual property. And that's for two reasons. One, they scream the loudest, both formally inside the room and in back channel calling and putting pressure on both staff and board. But more importantly, they also have great levers to pressure their governments. And then you see the governments putting pressure on ICANN staff and board. It's a difficult position for staff and board, but I will tell you that the negotiation has been sort of tainted by that kind of misrepresentation or that overrepresentation. And sadly, it's coming down to low comedy, where the final sticking points in the contract. Everything but these final sticking points could have been agreed to, as far as I'm concerned, in Singapore, which is now 4 meetings ago, or 15 or 16 months ago. And these last 2 points, which are primarily validation and data retention, not only are not resolved yet, but are pointless. So with validation of users, it's now some artifice of validating an email address or a cell phone number, which everybody on both sides of the table agrees anybody engaged in any sort of real wrongdoing will easily avoid. And so this won't really stop anything, but it will provide a nice control mechanism for the people who use the DNS appropriately. And with data retention, it's now come out that what is being negotiated and what law enforcement has asked for, and through staff has asked for, is in excess or far in excess of what's legal in the EU, what's legal in Canada, and probably in a number of other places in the world. So now you have to have opt-out provisions, which means that it's virtually not going to apply, or it's going to apply in so few cases as to be irrelevant. So you have these 2 sticking points. You'll see them talked about a ton this week, and they're both irrelevant, which makes the whole thing farce or low comedy to me.
Yes, how can I follow that by talking about the 2 irrelevant issues? But issues that remain on the table because they are critical sticking points in the use of the DNS and the use of the Internet for free expression and free association. Because to an individual or organization seeking to speak and be found on the Internet, registering a domain name is often a critical piece of the process. And to do that, individuals and organizations shouldn't be forced to provide for public access huge amounts of information leading back to personal telephone numbers and email addresses and home addresses. Shouldn't be forced to pre-validate that information before the domain name resolves, and shouldn't be told that for an indefinite period of time, long after their commercial relationship with a registrar may have ended, that data will be stored for potential access by those seeking to find them. And so let me put this into a concrete context. Say I'm listening to the presidential debate back in, again, I'll show my U.S. roots, but maybe some of you outside the United States were also watching that first presidential debate. I hear there's some interest in U.S. presidential elections even beyond our borders. So Mitt Romney says at one point that he apologizes, he really likes Big Bird, but he would pull funding for PBS. And listening to the debate, I decide I want to register Big Bird for President. .com. In fact, looking at the Whois records, I see that Big Bird for President was registered on October 3rd, the day of the debate. And But unlike the person who registered that, who currently has it just pointing to a landing page, if I have content that I want to make available immediately and hashtag it on Twitter and post it so that people can find it immediately and continue to find it, I should be able to register a domain name and as quickly as I can get my hosting infrastructure in place, have that content available and accessible. And the benefit to a domain name as opposed to a Twitter hashtag is that I am in control of it and in control of where it resolves and can keep that alive even if Twitter decides to change its access mechanisms or other people from the other side of the debate colonize the hashtag and try to make it point to material supporting the other presidential candidate. I won't say who that might be. But Oscar the Grouch, perhaps. So the domain name there and its instant availability for resolution becomes an important tool for political speech and political organizing. And so changes to the registration process, as for law enforcement is asking that information be validated and verified before a domain name would go live, could delay that, could make it impossible for me to speak immediately following the debate when the issue was most live to people watching, could make it difficult for me to pull together an email list of people who are interested in helping Big Bird to mount his campaign or helping the supporters of public television more broadly to assure that the candidates who support continuing that public funding of educational resources get support. So we need to preserve that ability to speak. And in that debate, the non-commercial, in the more general RAA debate, not in the presidential debate, the non-commercial users constituency reached out to data protection authorities, sent a letter to many of them raising these concerns about the overbroad collection and retention of information. And so the Article 29 Working Party, the group of data protection authorities in Europe, wrote to ICANN, to the chairman of the board and CEO, to raise concerns about the collection and retention of information. And they raised concerns going to the very heart of the Whois, saying we really need to return to what is the purpose of Whois information collection, because a core principle of European data privacy regulation is that information must only be collected and used for the purpose for which it was needed in the first place. So if we know that Whois information is needed to resolve complaints about abuse of the domain name, we could say a far more tailored collection and availability of data would serve to help someone get in touch with an abuse contact and to stop the abuse of a name. That doesn't mean that information needs to be publicly available in a public database and held for long after the domain name remains resolvable when it can no longer be abused. So we've been seeking to bring these public interest perspectives into the discussions around the Registrar Accreditation Agreement, and to say that even though that this is a commercial private contract, it fundamentally affects the rights of every member of the public who seeks to register or communicate through a domain name registration, communicate through an internet site whose point of contact with the world is often a domain name. And so we thank the registrars who are standing up for the interests of their registrants, and urge ICANN staff to listen more broadly to the concerns of all of their constituents, not just law enforcement and some intellectual property holders, in maintaining these contracts as a balanced commercial arrangement and not a special purpose enforcement mechanism.
Great. So I sense there's, Elliot's sitting here nodding his head, agreeing with a lot of what you were saying. But you also mentioned that you think that they're pretty close to being done with the 12 points here that law enforcement has proposed. So are we that close, or are we not close? And obviously, how do we incorporate non-commercial voices?
I've been involved in a lot of contract negotiations in my day, and saying that you have 10 of 12 points decided and only 2 remain. This is as close. Yes, it's very close, but it's also it's been this way for 2 or 3 meetings now. And it does look, good news, Wendy, it does look like pre-validation is gone by the wayside. And, I think that's a point where registrars really dug their heels in. And it's only in the last couple of weeks that we've really seen these additional government actors, the e-privacy people. The Canadian privacy people haven't weighed in yet, but I can tell you my position is that the data retention violates Canadian law as well. So you're just seeing the onset of that. I'm very interested to see how the GAC now has to deal with a bit of schizophrenia, and I'm looking forward to that this week. I think it'll be great in their evolving role to see that challenged. There's another point that I really want to tease out here, though. That, I mentioned at the beginning I had 2 major points I want to make, and that's that it really has to be the case. We're seeing a change in ICANN now with the new GTLD process, and that change is going to fundamentally change the way that I think groups have worked together. And one of the things that I put out very provocatively, almost controversially, on the registrar list recently was that Tucows or GoDaddy or Enom or any registrar that deals with domain names to end users has a lot more in common with NCUC and what I wish ALAC would focus a little more on than we do with registrars who represent brands today, and most importantly, than registrars or registries who are single registrant or brand TLDs tomorrow, which would be the majority of registrars and registries just on the numbers. So there's a couple important points there. Is you now see a schism in what has traditionally been registrar-registry, and you also have a new anachronism. And you're going to hear me say this a lot this week. Not new anachronism, that's hopefully the only time I use it is here. But the terms contracted and non-contracted parties were a convenience of the previous reform and are now irrelevant. So I think we all really should just stop using those terms as of today, wash our mouths out with soap anytime we do, because all they do are mislead people. The fact that somebody has a contract has no bearing on whether they have common policy grounds with another party. I can sit here and tell you, second largest registrar, largest wholesaler, we have almost every issue in common with NCUC and, in my wishes, ALAC. And I say that with respect, not in any sort of bad way, than we do with so many others who we're often sort of put in with. And I think we all have to realize and recognize this new reality and take advantage of it and form deeper bonds than we have in the past and be much more effective in advocating for users, because that's what it's going to come down to.
Great. Thank you, Elliot. Kathy, are you ready for a response?
I am. And on the substance issues, actually, I just want to applaud Elliot, Michele Nalon, there are registrars who have gone to bat for registrant rights and for everyone's rights. But I'm going to comment, I'm the boring person. I get to comment on process, procedure, and precedent. And it sucks. This is bad stuff. I've watched a number of very important policy issues taken out of the policy arena and brought into the private negotiating room between the registrars and ICANN staff with this registrar accreditation agreement. The rest of us are arguing outside the room, and we're arguing for better privacy. We're arguing for protection of rights. We're arguing for due process. But these are the same issues that we're arguing for in the ICANN policy arena. So when I watched the Who Is issue that we had the review team on that is going into a PDP, the policy development process of ICANN, to balance it out and have the different voices. When I want to kind of yank and put into a private contract process, I'm like, wait a second, this is not the right way to go. Contracts shouldn't be used to change policy, to limit rights. I think we have to draw a clear line between what truly belongs in a purely commercial contract and what the policy issues are within ICANN and other places, and keep them separate. And we're not just seeing this in ICANN, guys. The precedent is there that a lot of policy issues are going into private contracts and lots of different platforms on the internet. And this is a great way to watch that our grandchildren don't have the rights that we have today.
I just come back at you a little bit. So why can't contracts be used to strengthen rights? Individual rights.
It's the process. Sure, on substance, you can win an individual contract round, absolutely. But the process of excluding the voices, of excluding, and I know it was criticized, the term multi-stakeholder, but excluding the principle of having the different groups around the table, it's, in the long run, you're not going to win. In the long run, the substance of what you decide, the policy that you make, that's like saying, for Congress, why bother to have all the voices in the United States, where I come from? Let's just have the best and smartest, and they'll tell us what the right answer is for legislation. We believe, whoever harkened back, I think our keynote harkened back to Greece, we believe, many of us believe in a process of democracy, and that you have the voices at the table to make the best decisions, to make the best policy. And watching those voices go through a funnel and get restricted, even if they are as good as Elliot and Michele, in the long run, that's not going to serve us well.
Yeah, I mean, Kathy, I think you have the most important bit that I want to pull out there. You have to recognize that the RAA is exceptional. And so when I say that, I mean it takes place inside of ICANN. We're in a world where power is shifting from the nation state to the corporation, good, bad, or indifferent, and it has all of those things. It has some good, it has some bad, and it has some indifferent. But, it makes me crazy to listen to a representative from PayPal stand up at the microphone and demand a seat at the table negotiating my contract, where I certainly cannot negotiate my PayPal user agreement with anyone, which again has significantly more impact. So, I think that it would be great, even if there was perfection in the ICANN negotiation around the RAA with getting voices in, it will not, by construct, be a model for the vast majority of those commercial negotiations, non-negotiations that take place around your Facebook agreement, your Google agreement, your PayPal agreement, on and on and on and on it goes. So I think that rather than dealing with what I would call real exception inside of ICANN, that point is an important one, and we need to figure out how to be able to apply it in a different forum, because, we could solve this problem with perfection, and it would be such a dust speck in that broader problem. So, I think that that's most important to me here, and really seeing this for what it is and what it isn't.
Agreed, and agreed that it's a much larger procedural due process problem across the board and with many, many, many different types of providers.
And, the other thing that I really urge you to do is to, I hear you hearkening back to some halcyon days of democracy that, no history book ever demonstrates existed. And we all do that, sort of, yearn for that perfect democracy of yore. Sometimes I'll hear the Constitution referenced like it's the Bible, just having equal, kind of weight, and certainly not by you. But, I think we have to recognize that there's opportunities that are great in the changes that are taking place. And we need to think about new frames, not harken back to old ones, because we're making stuff up here.
We are making stuff up, Elliot, but if we don't harken back to basic principles, and those principles have lasted a long time and they've served us well, and I believe that we're short-shifting them, and those principles have to do with procedural due process. And if we short-shift them now, it's going to be really hard to insert them later.
So I would agree with everything you said, except for what becomes a political science debate of, I don't believe those are long-lasting principles that have served us well at all. I think that they are principles that are important, and we can apply them better going forward than they've ever been.
Maybe with a lot of work.
Great. So, we at the beginning we said we wanted to spend some time kind of examining where we could go from here in terms of improving these informal processes that exist around seizures and also around negotiations in the RIA agreement. Kathy, you had touched on the notions of incorporating due process. Are there any other points that you wanted to bring forth?
Yeah, going back to the seizure, and I look forward to the discussion that we'll have because I know everyone is thinking about these issues here in the room. Going back to the domain name takedowns and the principles that I believe have to be there. Again, looking at the big picture, looking at what's missing from legislation, from court tribunals and court-ordered takedowns, from law enforcement takedowns, from the private takedowns that are taking place. Let me just suggest that there's some basic rules of fair play that we should be building in, and I don't think we're doing. And when I tell them to you, you will nod because they're so basic that it seems incredible that we're not doing them. One, and there's only 4, guys. One is notice. The right to know that an accusation has been made against you, your property, or your liberties. Basic principle. 2 is response. The ability to respond to a charge against you, preferably in some form that you can reach, in a language you can read, and with the help of an expert that you can bring. 3, fair decision making. This is the value we place worldwide in the fair and impartial decision makers who listen to both sides and render a fair decision. And 4 is appeals. When you believe a mistake has been made, as in the Roja Directa case, the right to point it out and have a proceeding review it in a timely and fair manner. And this didn't happen with Roja Directa. I believe if we don't build these 4 principles of procedural due process into our systems, we'll lose them. Basic principles. Thanks.
Thanks. Don, are you still there?
Oh, yeah.
Okay. Feel free to chime in. The rest of our panelists are going to respond to Kathy's comment.
Okay. Hard to know where to start. I mean, for the most part, I agree with the principles that Kathy mentioned, without any doubt at all. And by the way, Roja Director was not the only one treated shamefully. DJAZ1 also got its domain back, but after some absolutely shameful delaying tactics by the U.S. government. And I don't remember if it was ICE or the Department of Justice who involved at that stage of the process. I think there's something that okay, start over here. And this gets back a little bit to why I was suggesting that discussing some of these issues in the context of intellectual property is too small a scope. I certainly agree with the concept of court. And by the way, one of the best ways to get a fair hearing would be to have a whole lot more prosecutors and judges who understood what was being laid in front of them. But that's going to take a while. One of the issues is when the notice has to be made. And the fact is, all of the defendants here, in theory, got notice. They received notice concurrently. And I'm seeing people looking at each other. I said in theory. The fact of the matter is that ex parte actions have been in law enforcement forever. And in some cases, there's a strong argument that it's the only way to go. I can speak from experience, and this wasn't an online case, where if we had not had, we didn't get an ex parte action, and as a result, the case died. End of subject. There is an argument to be made for them, I believe, having been in law enforcement. Are we suggesting here that we go back to square one and just say that that type of action should be eliminated from U.S. jurisprudence and potentially other countries? Again, I'm U.S.-centric. For the record, I think that companies would be very hard, the government is hard-pressed to justify an ex parte action in an intellectual property case. I think in other instances, the harm, what's the word? In some cases, I think the harm of not doing it ex parte outweighs the benefits.
Great. Thanks, Don. Genevieve?
So I'm not entirely clear on what you meant by the websites that had been seized had received notice before this. Certainly, Roja Directa did not receive notice prior to the seizure. Right, but at that point, that's not okay. So concurrent, sure, but by then it's a little bit too late to say anything, and then you're caught up in these really complex, delayed administrative proceedings where the government has, 90 days before it has to actually notify you of the seizure. They're just the laws are very tilted toward the government and toward delay. The other, I think that the problem currently is that every proceeding, all of these are ex parte without any sort of, even if there are certain circumstances where there may be a need for ex parte seizures, there needs to be a mechanism to establish that need, similar to another civil litigation where the normal procedure is you provide the other side with notice. And here, there really is not, for instance, the risk that the client is going to abscond with the domain name or destroy it. And if the concern is destroying evidence, the evidence is on the server. It's not the domain name. And these actions are not targeted at the servers. So I think that there really is not. I don't see a huge need for ex parte proceedings in these types of cases.
I agree. Like I said, that's one reason that I think domain takedown discussions need to be broader than intellectual property cases.
Great. Wendy?
Thanks. I'm going to take the opportunity to shift the focus just a little bit because I think a lot of what we're talking about here is about the public-private balance that we see in Internet, in ICANN, in individual actions. That one of the unique features of ICANN is that it's starts from private sector coordination and consensus processes, and it unites lots of people who have different sorts of private arrangements with one another. Lots of the takedown mechanisms and negotiations happen in private contexts without ever getting out to even the kind of courtroom proceeding that a Roja Directa ex parte order eventually offers. And sometimes those can be useful. Sometimes when there's a quick response to a clearly malicious botnet domain registration, it's useful that parties can get together and say, we recognize this activity, we've seen it before, here's the record we've developed, let's take them down and stop them from registering new domains to propagate the botnets. That kind of coordination is useful, it's helpful, and it's not something that we'd say should stop. So what sort of due process and procedural protections should we bring to these public-private partnerships, I think a critical additional element is transparency, is creating a public record that can be shared and that can provide opportunity to get notice and respond and to assess the fairness of these proceedings. At some point that will be advanced. At other points it will be a record that comes up afterwards when somebody wants to raise a challenge. Organizations like Chilling Effect, but certainly not limited to Chilling Effect, try to help gather that record, help to allow the public to assess how well are these processes working, where do we need additional safeguards, where are they working effectively for us as they are, so that we can tweak the processes, recognize that there are lots of new contexts, and help to get the public interest recognized in all of these different contexts.
Great, thanks. We got a quick comment from Elliot, and then we can take one, maybe two questions from the audience.
You know, I think we need to recognize that extrajudicial takedowns take place every day, and they are a good thing. And they also serve to, you know, kind of obviate Kathy's 4 points on one level, and I want to add to that. You know, the way that it works in practice is people like PayPal or the banks, their security people have a relationship with our compliance people. Things are taken down over a phone call and a look at a web page, and that's a good thing. There is no notice, there is no due process, there is no transparency around it, and the bad guys deal with it. That's a cost of business for them. And what's most important is when, you know, I don't question whether notice, response, a fair decision, and appeal are important elements. They're not sufficient. In order to have protection, we need to look at what the bad guys do and what WikiLeaks does, and that's use the internet and learn from the internet, which means resilience and redundancy. Because that's why they don't care that we take down their stuff within an hour every time. And we all need to recognize and learn that trying to shoehorn the historical legal processes around this world that we now live in is just an ill fit. And so, you know, I really want to just encourage us to think forward there.
Great. We can take a question if someone has a question, and then we will cut it off.
Hi, it's Evan Leibovich again, and I wanted to go back to what you said, Elliot, about using the word transparency and applying it back to the RAA, and touching on stuff that both Kathy and Wendy have mentioned as well. And that has to do with if there are complaints about how law enforcement is getting involved in the RAA negotiations or whatever, isn't the best way to deal with that is to get a little bit of transparency in that process? It's a little bit disingenuous to talk about having PayPal in the negotiations. At large is asked to be there. We've been turned away. And I would like to have some kind of a transparency process that will allow something in the room that would allow the information to come out. So if this group is putting on too much pressure, if there's this much pushback, or if staff is doing something counter to policy that's been made, having a little bit of transparency in the room can go a long way. And it's not just PayPal that's been asking for this. And so if you're talking about, you know, you mentioned earlier the disjoint between ALAC and what you're talking about, you know, maybe a little bit of openness in that direction might help. Thanks.
Evan, every single draft of the contract is posted. All of staff's comments on the sections are posted. All of registrar's comments on the sections are posted. And we get no input from ALAC. Instead, there is focus on issues that I can only describe as intellectual property issues, and I don't know why ALAC is bringing those forward. You know, I mean, we can take this offline, but this is the most transparent commercial contract negotiation, I would argue, that exists. You know, PayPal asking to be in the room, again, you know, there is no room. There is no room. They hand down their contract to you. You like it, you take it. You don't, you leave.
Hi, I'm Kenneth Morgan, and I'm the voice for the people who are asking questions through the webcast. And I have a question here from Rudy Vansnick. We very often see parties taking advantage of the lack of appropriate law in a country to abuse the whole TLD system. Who will govern the gap between the contractual ICANN elements and the national laws? I don't know what that means, but that's the question.
He's got this one.
So I'm also I'm not sure what the question is. I think one of the we have national laws applying to actors in the countries where they operate, and in the country, as we've seen through domain takedowns, they may be operating in many more countries than they think by registering a domain name in a registry or with a registrar who's in a different jurisdiction. One of the principles that I think is important in the expansion of new TLDs is the opportunity to have registries located in different jurisdictions subject to different legal regimes that might, for example, give registrants more privacy and security in their registration and might be able to comply with the different privacy demands of different jurisdictions. So I think we'll see a useful increase in variety of jurisdictions and an increase in opportunities for experimentation there. And then we'll see what people choose based on those increased options.
Awesome. Thank you very much.
I'm just going to give a quick second answer, which is watch the danger of the precedent, guys, which is just by virtue of the fact that a registry is located in a particular country, do we want the laws of that country to reign over the registrant who may be in a completely different country and the registrar also in a different country? Just because it's .com and it's located in the northern, in the Eastern District of Northern Virginia, does that mean that we want any kinds of laws, U.S. pharmaceutical laws, reigning over pharmacies that are in other countries serving under their laws to people and customers that are not in the United States? I've had this argument many times at the White House and with law enforcement. So let's be very careful of the precedent that we set up, that the law of the registry is what will govern, because if there's a registry in Saudi Arabia, let me tell you, I'm concerned.
Great. Bertrand, with the proviso that you're cutting into coffee break.
Okay. Just one point to Elliot. You pointed very rightly, one of the challenges of the RAA is that there are two extreme positions. One, it says because it takes the form of a commercial contract, it should be negotiated only between the two parties. The other part says because it embeds policy provisions, it should involve a larger process. I think we have moved a little bit forward in the last few months to try to find this balance. And on a personal basis, I consider it extremely important that the Article 29 and the privacy actors are in the picture. And I support the notion that it is a challenge for GAC to know how to accommodate the participation of all the different agencies and entities. I'm not even talking about parliamentarians in that debate. The second thing is going in the direction that you and Kathy were discussing. If you make the parallel to very large online platforms, in the program that I'm running on Internet and Jurisdiction, we push a saying that basically the terms of service of platforms are like the law of the digital territory. And one of the big challenges is precisely how are those terms of service developed? How are they implemented and enforced? And the due process question comes into play. Just as a quote, in a workshop we organized in Stanford, and I won't say which were the companies who said that, at Stanford a couple of weeks ago with major platforms. One actor said initially the terms of service were mostly a cover your ass policy, like I'm not liable for anything. And the other party said, and it has evolved in something that is accidental constitutions. Because they compose now such a range of issues that cover the relationship with the users, relationship between the users, and so on, that it becomes basically the law of a digital territory. So your point about this should evolve as well is a very interesting element. Thank you.
Any final, anything from our panel? Okay, if you'll please help me in thanking our panel. Thank you. There's a coffee break at the back of the room.